For this meeting, having arrived, the Standing Committee on Environmental Resources and Energy will come to order. I'll ask Ms. Weaver to please call the roll.
Chairman Marr.
Here?
Bloom.
Here.
Hauser.
Here.
Christiana.
Here.
Corbin.
Here.
Everett. Gobler. James. Thank you. McKenzie.
Here.
Marshall.
Here.
Metzger.
Here.
Mustio.
Here.
Pyle.
Here.
Rapp. Here. Sankey.
Here.
Tallman.
Present.
Chairman Vitale.
Here.
Barbin.
Here.
Briggs. Gibbons. Harris.
Here.
Kruger Brennecke. McCarter.
Here.
Newman. Schlossberg. Schreiber.
Here.
Snyder.
Thank you. A quorum being present, we'll proceed to the substance of the meeting. Today's meeting was announced notionally several weeks ago that the committee would be considering its response, if any, to the Chapter 78 and 78A regulatory analysis form and proposed regulations submitted to the Independent Regulatory Review Commission. The Regulatory Review Act provides a rather complicated flow of options that this committee may act to disapprove, may act to approve, may act to notice an intent to review, or may take no action. So the question that the committee has before today is, do we desire to take any of those steps? The chair recognizes the gentleman, Representative Causer, the purpose of the motion.
Thank you, Mr. Chairman. Mr. Chairman, I believe very strongly that DEP and the EQB have promulgated regulations that are fatally flawed. And both the Chapter 78 and Chapter 78A regulations are unlawful and should be disapproved. And I'm going to cite two reasons. There are multiple reasons for my belief. Number one, there's a clear violation of the Regulatory Review Act. The Regulatory Review Act requires that forms or reports which will be required for the implementation of the regulation and an explanation of measures that have been taken to minimize the legal requirements must be included in the regulatory analysis form and presented to ERC. In this case, dozens of new forms are central to these regulations.
Representative Causer, could I just interrupt? Were you going to make a motion, and then you can offer
Okay, I'll make the
remarks
motion.
on the motion?
Absolutely. Mr. Chairman, I move that the committee disapprove the regulation and authorize the chairman to send a letter to ERC and the EQB to that effect.
Chair,
And I
thanks,
was
gentlemen.
explaining my
Is there a second?
rationale.
Seconded by Representative Rapp. Representative Causer, you recognize on the motion.
Thank you, Mr. Chairman. In this case, dozens of new forms are central to the regulations. These critical forms were absent when the regulatory analysis form was first presented in 2013. These forms remained absent when the advance notice of final rulemaking was published in 2015 by DEP. These critical forms were still absent when the regulations were considered by EQB on February 3rd, 2016. And most disturbing at all was at the EQB meeting, the Office of General Counsel admitted that they knew of the statutory requirement and ignored the law. They blatantly ignored the law. So, Mr. Chairman, this clearly violates the Regulatory Review Act, and in addition, it violates Act 126 of 2014. In the state fiscal code in 2014, there was a requirement that regulations be promulgated separately for conventional and unconventional wells. Instead, the Environmental Quality Board promulgated the regulations together. A very clear violation, and this is a very important separation of powers issue. The conventional and unconventional industries are very separate and very distinct and should have regulations built around those separate industries. The intent of the law was for the DEP and the EQB to start the conventional regulations over again. And the DEP and the EQB ignored the intent of the law. They ignored the intent of Act 126 of 2014 and moved forward with these regulations. And Mr. Chairman, that is wrong. Even Chairman Vitale at the time on the House floor stated that the intent of Act 126, or what the response would be following Act 126, was it would require DEP to start over with the conventional regulations. But in fact, DEP did not. So there are multiple reasons today that these regulations should be rejected, and I urge the committee members to vote to disapprove these regulations. Thank you, Mr. Chairman.
Chair, thanks to the gentleman. On the question, recognizes Representative Vitale.
Thank you, Mr. Chairman. At the outset, I would like to condemn the procedures of this hearing today. The chairman gave us no notice that this orchestrated attempt would be made. We've made repeated attempts, starting with a personal call to Mr. Chairman on Thursday, emails on Friday, trying to get the contents of what would happen today. I also want to express my disapproval at not receiving simply the common courtesy of allowing to be made opening remarks until this orchestrated attempt was made. It is very basic to this system that members be given notice of what will be conducted at the hearing, and I want to condemn that. Moving on.
You gentleman will suspend. There was notice given several weeks ago in this very committee.
Notice was Thursday. This meeting was given notice Thursday.
Chairman, would you please suspend?
I was the one speaking, Mr. Chairman.
You're out of order.
No, you're out of order because you interrupted me. I was recognized, and I did not yield the floor to you.
I didn't ask you to yield. I asked you to suspend. The rules provide that personal attacks are always out of order. You're making ad hominem attacks using incorrect statements. Now, if you wish to speak on the question, please do so.
I will.
If you wish to continue this other thing, please do it at your press conference.
I will speak on this. These regulations are pursuant to Act 13, which we passed over 4 years ago. These regulations are long overdue. These regulations relating to oil and gas have not been revised since 2001. They are long overdue. These regulations have been the subject of 20 advisory board and committee meetings, 135 days of public comments, 12 public hearings, and almost 28,000 public comments have been received here. I have been working on this for 4 years. I have no doubt there is a concerted effort by the conventional drillers simply not to be regulated here. That's really what's going on here. These regulations have common sense protection to the public. There are regulations which apply to both conventional drillers and unconventional drillers, and there are very distinct regulations that comply to conventional drillers only. I'd like to take some time to review those similarities and those differences. They require both conventional and unconventional drillers to do a pre-drilling analysis of where the drilling will occur so you don't get into drilling into abandoned wells and already existing wells. That's a very important safety requirement because if you drill into an abandoned well or an existing well, there are many environmental consequences that flow from that. So it requires a basic obligation on the part of one who would drill to do that pre-drilling review. That's important and that's protective of public health and the environment. With regard to both conventional and unconventional drillers, it has a very important environmentally protective requirement that if oil and gas development degrades a water supply, the operator has to restore that to Safe Drinking Water Act standards. That's an important thing to protect public health. Both conventional and unconventional drillers are required to do that. These regulations also contain important provisions with regard to the requirement of cleanup should either a conventional driller or an unconventional driller spill. They talk about things like the quantity of spill that would require a cleanup and then the length of time that cleanup must be conducted and completed in. They are very important common sense requirements, and I'm not going to get too deep into the details of that, but they also require differences between conventional and unconventional drillers. And I've seen how we've run these together, we've bifurcated them, but they do treat unconventional and conventional drillers distinctly different here. For example, vandal-proof tanks. It's only the unconventional industry that has to install things like valve locks, open caps, retractable ladders, and other things to prevent vandalism. Conventional drillers don't have to do that. That's a difference. Also, with regard to the use of pits, unconventional industry is prohibited from utilizing pits to store drill cuttings and waste fluids. The conventional industry, as distinct from that, will be able to continue to use pits if they come within certain volume requirements, which I won't get into. Another key difference is the disposal of drill cuttings. The conventional industry has to require an individual permit to dispose of drill cuttings. The conventional industry does not. That is another difference of the many differences between how conventional and unconventional drillers are weighed here. Another area of difference involves secondary containment. The unconventional industry is required to employ secondary containment measures. And these are important because if there is a spill, the secondary containment measures can catch that spill. These secondary containment measures are required around storage vessels, trucks, drill rigs, and so forth. That piece of the regulation is not imposed upon the conventional drilling industry. Gathering lines is another area of difference. Temporary pipelines is another area of difference. Water management plans is another area of difference between conventional drillers and unconventional drillers. These unconventional rules will be considered requires operators to obtain water management plans before they withdraw water for hydraulic fracturing. The conventional drillers do not have to do that plan, so that's another of the many differences. Beneficial use of brine. Conventional operators can use beneficially used brine for dust suppression and de-icing purposes. Conventional drillers cannot do that. So there are many, collectively, what I've listed are many important provisions in these regulations which will protect public health and the environment, but also there are many differences in the way they are treated because they are two different types of operations, and these regulations recommended that. And I just want to read something that relates to Mr. Causer's motion with regard to the illegality. I'm just going to read it, and I apologize for that because I don't think I can get it right if I don't do that. It goes about 8 lines.
Would the gentleman suspend for a moment? Actually, under Jefferson's manual, the reading of documents into the record is actually a violation. We've granted some leniency in the past. I'm going to go ahead and grant a little bit of leniency here. But I'm not going to allow it to be a dilatory thing where you're just going to be reading and reading and reading.
It's going to take 8 lines. Some have criticized the procedural steps the department took when submitting its regulatory analysis form. In fact, the department complied with this requirement by submitting a complete and comprehensive regulatory analysis form on the same day it submitted the proposed rulemaking package to the Commission, legislative bureaus, and committees. After holding 2 public comment periods, 12 hearings, 24 advisory committee meetings, and receiving nearly 28,000 comments, they faced the monumental task of incorporating this stakeholder feedback into the final form regulations and revised regulatory analysis form in a timely manner, a task they successfully completed. I think that these regulations are long overdue. They're desperately needed. They're needed to protect the public health. And I would urge the committee to vote against the Cowser motion and let this process take effect, and let's stop these delaying taxes. I also might note that there's been 2 attempts in 2 different fiscal codes over the past 4 years by legislative action to cancel these regulations. One required these regs to be bifurcated, and in fact, they were bifurcated. And then the second, most recently, again, even though they have been bifurcated and went through the hearing process again, stopped, tried to cancel these regulations. So this has been a consistent effort by the conventional drilling industry and those who would do their bidding to stop these needed regulations, and we need to just move forward and get them enacted into law.
The chair thanks the gentleman, and on the question recognizes Representative Rapp.
Thank you, Mr. Chairman. I just want to say that I appreciate the comments and the motion by my colleague, Representative Causer. I myself attended one hearing that was in Warren County at the request of Representative Causer, because all of the hearings prior to that hearing focused completely on the Marcellus. The only hearing in the state, to my knowledge, that focused and allowed the people who represent the conventional industry to be heard was the hearing in Warren County. And throughout that hearing, we heard from the conventional producers, who are actually all small business people in this state. And there is a section that we believe violates the Regulatory Review Act, the Small Business Statutory Requirements, that sets regulatory requirements specific to small businesses, including an economic impact statement and description of any less intrusive or less costly alternative methods of achieving the purpose of the proposed regulation. The small business provisions of the Act were ignored in the original regulations and in the regulations that were submitted in March of 2016. There have been attempts to substitute chatter, contrasting conventional and unconventional operation differences, which has absolutely nothing to do with the impact on small business or less intrusive or costly alternative methods. The proposed rule contains not a single provision specific to small businesses. The hearing at the Warren County Courthouse, Mr. Chairman, was specific to those issues of the conventional producers who are small businesses, and not just the owner-operators, but the next generation of those conventional well producers and owners. Young people in high school who talked about working in their family business and how discouraged they've become, looking at the industry that has been around since 1859, since Edwin Drake drilled the first well in Titusville, Pennsylvania. The testimony that we heard that day was, quite frankly, very enlightening to hear from the next generation of wanting to be producers of one of the greatest industries that we have seen in this state, an industry that helped win 2 world wars, an industry that produces many items that people aren't even aware of, the plastic industry and the medical, all the innovative medical research. If you walk into a hospital today and look at everything that's made from plastics or in your car and in your home, those are all products that originated from the conventional oil industry in the state of Pennsylvania. And we should be proud of that. And every time we try to address this issue, it's just attack from the other side on this issue. This industry is regulated today. Our folks up in northwestern PA have more boots on the ground from DEP than they've ever had before. Because DEP was allowed to hire more and more staff to be on the ground, and since the Marcellus industry has moved out of the state, guess where they're going? They're going to the conventional sites and trying to find every little notice of violation that they can find to fine our guys, and most of them have laid off every single employee they have because of the regulations promulgated from this legislation. It was never our intent, my intent. I was here making the vote that day. Our folks have had numerous meetings with even people in this audience trying to demonstrate the difference between conventional and the Marcellus industry to no avail. We are losing an industry because our folks cannot comply with these strict regulations and stay in business. I implore you to cast an affirmative vote on Representative Causer's motion and my second.
Chair thanks the gentlelady, and on the question recognizes Representative Kruger-Branicki.
Thank you, Mr. Chairman. I feel compelled to speak in opposition to the motion this morning. Over the past 24 hours, I've received 123 emails from residents across the Commonwealth urging this committee to take action. My understanding is that this is a process that began under the last administration, has been in process with countless public conversations and conversations within the legislature. And fundamentally, for me, this is a conversation about clean air and clean water. We, as legislators, have a responsibility to protect the people of Pennsylvania, to protect the children, to protect the families who are living within close proximity to these sites. And I believe that the process has been thorough. I believe the process has been legal. I believe the process has correctly addressed the needs of small business operators and also correctly addressed the responsibility of multinational corporations. And I believe that this committee has the responsibility to act. So I will be in opposition to this motion today. Thank you, Mr. Chairman.
Chair thanks the lady and recognizes the gentleman, Representative Pyle.
Thank you, Chairman. I have a question on the motion. May I ask? I'm sorry, I have a question on the motion. May I ask that of the maker?
You may.
Okay. Representative Causer, you and I have been on this committee with Representative Vitale and Representative Rapp for 12 years.
14.
14 for you. I only got here 12 years ago. I've missed in those 12 years 4 meetings. 2 of them for the death of my sister and 1 for the death of my father and once when I was sick. I don't recall when we were forming Act 13 that it included conventional wells. Earlier you said that when DEP and EQB promulgated these rules, they violated a number of existing Commonwealth laws that had been passed over the last 4 years. Could you please elaborate on that a little bit? You read off a list of all the things they did against the law, and I just wanted to note those.
The points that I made were that the department violated the Regulatory Review Act in many ways by not providing appropriate information that's required under the Act and required to be submitted as part of the regulatory analysis form. So these are very clear violations and in fact are a problem for public transparency. These are documents that under statute and regulations are required so that the public knows what is being submitted or proposed for regulation. So there's a very clear violation of the Regulatory Review Act transparency requirements, and then a very clear violation of Act 126 of 2014.
Thank you. And earlier, Representative Rapp said there was a issue with them not furnishing any economic impact assessments of this promulgated rule. Is that, am I right?
The gentleman's correct. There's a section in the Regulatory Review Act entitled Small Business Statutory Requirements, whereby we're supposed to consider the impact on small business when crafting regulations, and there again, the DEP has completely ignored that requirement in violation of the law.
Thank you. I'm aware that this is also the reason the Supreme Court of the United States has put a stay on the Clean Water Act, that the people on the federal level, EPA, furnished no economic impact studies for the rules they were promulgating.
Mr. Kyle, if you'd stay on the question before us.
Thank you. Chairman, may I comment on this motion?
You may continue.
Mr. Chairman, I appreciate that people come here with their own volitions. Now, earlier we heard this is needed. It's been tried for 4 years. I recall making votes on the House floor on such motions. None of them ever gathered a Democratic majority of the Commonwealth of Pennsylvania. You took your shot. You lost. So now we find ourselves going to a non-elected body. I dare anybody here to identify 5 of these people who are making rules that affect people, as Representative Rapp identified, who are dependent on these industries to feed their families. Now, earlier we heard from one of my colleagues that say we need to protect the families. Armstrong County has 14,000 conventional wells. Indiana County has 17,000. We're okay. We're not having health issues. We're not having water issues. Our conventional industry, you know, the one that's heated our homes for 50 years, is okay. Now, if we're going to make the cost of doing business more expensive, at very least, Chairman, I must insist the rule of law is followed. And I would encourage people who don't agree with what the vote of the legislature was to do better. Please vote for the Causer amendment. Thank you.
Chair thanks the gentleman and recognizes the gentleman, Representative Barbin, on the question.
Thank you. I just have a comment on the motion. Number one, everybody in this room, because we're legislators, understand a very basic premise, and that basic premise is the power to tax is the power to destroy. Everybody understands that one. If you tax at 100%, you eliminate all of the right of a property owner. There's a similar corollary to that, and that is that the power to regulate can also be the power to destroy. That's just a fact. If the regulation cost is so high, you put people out of business. And when you put people out of business, what happens is they abandon whatever property they have. The property that is the subject of this motion, as I understand it, has been discussed for a few years. Initially, it was discussed in the context of it's okay to have one set of regulations. It's going to cover the conventional drilling as well as unconventional. Now, that was separated in this most recent version of regulations. But what wasn't separated was the fact that the conventional industry, which is a whole lot like the old coal industry, is going to be subject to a system of regulations that will require people to abandon their property. We have an incredible number of uncapped conventional wells in Pennsylvania. Those are the most serious threat to our water sources. So, these are the issues. We all have to decide what to do at this particular moment. We all want to protect the resources of the Commonwealth. We all want to make sure that people's property rights aren't taken away without some reasoned approach. At this point, based on what I've heard, I'm going to be agreeing to the motion because you haven't followed the rule of law as it relates to conventional well owners. If we follow this law right now, if we go ahead and vote for this bill as it currently stands, we will have said it's okay to tax through regulation conventional well operators out of business, and they will end up being just like the Berwyn and all those other coal companies that left their bony piles on the sides of streams, and we are still dealing with those issues today, 100 years later. They're two different industries. We got to treat them as two different industries. Yes, we need to protect the water for both of them, but they both need to comply with regulation. Otherwise, we are going to make the situation we have today worse. I'm voting yes on the motion.
The chair thanks the gentleman and recognizes the Representative Metzger on the question.
Thank you, Mr. Speaker. I think that we can all, to echo the thoughts of my colleague from Cambria County, I think that we can all come together and realize that this isn't necessarily just about how we feel about the oil and gas industry, that this is an opportunity for us to recognize that we are the people's body, that there are 203 of us elected, and we have 203 different backgrounds, 203 different sets of finances, 203 different sets of ideas. But there is one governor and one set of unelected bureaucrats that have made a decision that's outside of the will of the people, what the people's body has decided. And we don't always get to agree with the majority opinion of this people's body, but several things have happened here, and we need to make a stand and say that this is where we make the law and you carry out that law. And I can see two things that I find particularly egregious. One is that, of course, Act 13 created a technical advisory board, and the RAF either misinterprets or completely ignores what the technical advisory board has come up with. And then the second part is that the governor even created his own entity with the Conventional Oil and Gas Advisory Committee, and when it doesn't suit, it is ignored. So when you ignore your own people and you ignore the will of the people through what the legislature has created, then it's the duty of the legislature to say enough is enough and we must stop. And so that's what I ask the committee to do today, is to support the motion by Representative Causer and say enough is enough. We are the will of the people. We were elected to serve. We have 203 sets of ideas, and this is what we can come up with. Thank you.
Chair thanks the gentleman. Is there anybody else seeking recognition on the first round here? Representative McCarter.
Thank you very much, Mr. Chairman. I appreciate the discussion today, and I appreciate the passion that many people have on this particular issue. And going back to Representative Rapp's comments about the history of the oil industry in Pennsylvania, I think that's something that's very important for all of us to know. I think that it has been an industry that has fueled a large part of the state's economy. It's an industry that has been very important to all of us, and as noted in many of the past centuries' conflicts, it played a major role, and will continue to do so at the present moment. However, the times are changing, and the reality is that we now know things about the oil industry and its impacts that we didn't know a century ago, and that many of these impacts on health, much like tobacco, are negative. And that's an unfortunate part of really what happens as we, scientifically look at the various impacts that occur. And one of the things that I think, listening to the debate today, that, this has been a long-going debate, a long-going struggle in looking at how we will regulate effectively. And that's one of the roles of government, is that we have to take that role of regulation very, very seriously when it impacts what happens in our environment, when it happens to our health, and that's what much of this is about today. Do the rules of Chapter 78 and 78A have an impact that would help our health in the state of Pennsylvania? Is it something that would help the economy of Pennsylvania? Initially, possibly no. They may have some detrimental impact in the very beginning. But it's something overall, when you look at the health of the entire state, when you look at the water resources of Pennsylvania, that can be threatened without adequate regulation. These are the things that we need to take into consideration that are critically important as well. And so in balance, it's very hard, and I hear the arguments being made by the other side. And does it violate various laws? That's what courts are for, to make decisions. So, we, in this particular case, feel the need, in this case, to give to the side in a sense of looking for the health of Pennsylvania and where we're going. And so for those reasons, Mr. Chairman, I will be voting no on the motion.
Chair thanks the gentleman and recognizes Representative Gobbler on the question.
Thank you very much, Mr. Chairman, and appreciate the comments of the preceding speaker. And I think that brings up a great point. Let's talk about what courts are for. Because in the 2013 Robinson Township decision, the Pennsylvania Supreme Court actually took parts out of Act 13, actually said that certain parts of Act 13 can't stand, specifically sections 3215C through E. Yet the RAF, as presented, includes regulations based on those specific parts of statute which have been removed. So we can talk about what courts are for, and I think it's important to do so. And in the case where we have a part of the statute that no longer exists, then the regulations that are promulgated as a result of the existence of those now barred portions of statute also need to be not included as part of the rulemaking. Yet, as it is in front of our Commonwealth, this rulemaking actually includes those portions, those out-of-bounds requirements. So I think that that is very important. Overall, I think it bears repeating that I think the gentleman from Cambria made an excellent point. Regulations, despite their intent, may actually have the countervailing consequence of making our environment less safe. And that's exactly what we see in a lot of the provisions in this, is that when you create something that is so egregious, something that is so costly, that it actually causes operators who want to do the right thing to not be able to do the right thing, then you will have environmental consequences. So it's important we go back to the drawing board on this. It's important that we say, look, we can actually arrive at reasonable sets of regulations. We can actually arrive at ideas that work, that allow these operators to stay in business and do so in a way that protects our environment. But to just go without following the rule of law, without following the direction that has been given by the elected legislature of this Commonwealth is really it would just be an absolute travesty, not only for the rule of law, but also for the environment. For those reasons, it is very important that we support the motion of the gentleman from McKean, and so I'll be voting yes, and I encourage all my colleagues to do the same. Thank you very much.
Chair thanks the gentleman and makes a last call for anyone seeking to make an initial remark. Seeing none, the chair recognizes as a courtesy the Democratic chair of this committee, Representative Vitale.
Thank you, Mr. Chairman.
On the question.
Probably the most knowledgeable person in this room with regard to these rules. And one of the prime authors of these rules is Scott Perry, the head of the oil and gas program. Now, I've heard a lot of questions. I've heard a lot of misinformation about the alleged illegality and yada, yada, yada. I would like Scott Perry to have the opportunity to respond to some of the more salient points and field any questions these members have. If we really want to get at truth, hearing from Scott Perry would be the way to get at that truth.
Mr. Chairman, I'm surprised you suggest that we haven't heard the truth from Scott Perry to this point. But in any case, we've heard it. We have heard that truth many times, but it's not reflected in some of the comments that were made. As you should
he knows his stuff, and he should have a chance to be heard.
As you should understand from having been the majority chair of this committee, your request is out of order. Is there any further comment you'd like to make?
Well, I mean, yes, and I think I have heard many times, and I've been on this committee for 20 years, and regrettably have not been the majority chair, but the opportunity for a head of a department or some other official to, when the committee is struggling with some difficult questions and some complicated matters, to just hear from that person who is in the audience is something that's commonly done, and it's not against our committee rules or House rules. And I would think if we really want to know, some good, solid information, let's let Scott Perry talk. If you really don't care about that, you just want to have these regs, defeated yet again, then fine. But Scott Perry knows his stuff, and he can answer your questions.
You're again out of order. You're attacking the motives of members. That's never appropriate.
Not attacking the motives of members. I'm just making a request.
Listen to what you're saying.
I am listening,
Mr. and you're your request is out of order. Do you have any further comments on the motion?
I think that what we have heard in summary with regard to what the actual contents are good common sense regulations that protect public health and the environment, that differentiate fairly between the conventional industry and the unconventional industry. You've heard the long path these regulations have taken over 4 years. The suggestion that we're not listening to the public is really contradicted by the 28,000 public comments we've received. The statements that there's not been opportunity for legislative input has been belied by the fact of the numerous public hearings where legislators, including myself, have testified. Legislators, including yourself, are in fact a member of the EQB along with other legislators. There is ample, consistent, voluminous opportunity for both the public and the legislature to have commented and continue to comment in the future. Again, what this is all about, in my view, is a consistent effort on the part of the conventional drilling industry year after year to prevent themselves from being regulated. And it's pretty clear they just don't want to pay the money. They did not want to pay the money for the severance tax. They do not want to pay the money to pay for these regulations. But public health demands it. And unfortunately, you don't want to have these issues clarified by Scott Perry. But again, I would urge a no vote on this motion.
Chair, thanks the gentleman. And on the question, I'm going to recognize the maker of the motion as the final person, unless I see anybody else seeking recognition. And then Representative, please proceed. And if there's anybody else, would you give me a hand wave? Okay, I see you too. So.
Thank you, Mr. Chairman. Much of our conversation this morning has been around the impact of regulations on conventional versus unconventional drillers. I've heard a lot of concern for small business owners who folks are saying are really the leaders in the conventional industry. I question whether that's true, but one thing that we can't dispute is that last year there was 1,024 violations of conventional drillers in Pennsylvania. 1,024 violations, cases where water could have been compromised, where children could have been exposed to methane leaks. I believe that today's vote is really a vote about clean air and clean water and protecting the safety of our children. And again, I urge a no vote on this motion. Thank you, Mr. Chairman.
Chair thanks the lady and recognizes Representative Rapp.
Thank you, Mr. Chairman. Most people know that I come from the Northwest, where we have had conventional drilling since 1859. It's one of the cleanest parts environmentally in the state of Pennsylvania. There's a 500-acre national forest in the area, and the Northwest, the area that I represent, including with Representative Causer, some of the cleanest streams in the entire state. There is a refinery in the one city that I represent, Warren, within Warren County. I don't live in Warren. I live right outside of Warren. But I had a meeting with a water company about 6 months ago, I believe it was. A water company that has businesses throughout the state of Pennsylvania. His comment to me, knowing that there are conventional wells all over the hillsides, the refinery, his comment to me at that meeting was, the city of Warren has some of the cleanest water in the entire state of Pennsylvania. This is a city surrounded by conventional wells. This is a city that hosts one of the oldest refineries in the nation. And by the way, that refinery, they bring most of their oil in from Canada, not the Middle East, that is imploding, exploding right now. So if you want to talk about clean air, clean water, I live in an area. We don't have emission tests where I live because we have clean air, we have clean water, and we have a whole lot of conventional wells and a refinery as well. And we happen to like the fact that we live in a very environmentally clean part of this state. Thank you, Mr. Chairman.
On the question, the chair recognizes Representative Causer.
Thank you, Mr. Chairman. Mr. Chairman, I think we can all agree that we want to protect the environment. We all want reasonable, responsible regulations. And in looking at what's been proposed specifically for the conventional industry, they are heavily regulated and have been for decades. The regulations that are proposed are irresponsible, unreasonable, and quite frankly, unlawful. There's been discussion that these regulations have been under consideration for some time. In fact, they started under the Corbett administration, and I'll be the first to admit that the Corbett administration failed us on this issue. And the Wolf administration has continued. In speaking of bipartisanship, both the Republican and Democratic Northwest caucuses, people that represent the oil patch and people that have a lot of conventional oil and gas wells, both caucuses sent letters to ERC asking for disapproval of these regulations. A bipartisan move because both Republicans and Democrats agree that these regulations are a problem, and once again, they're unlawful. So I would ask the committee members to support my motion to send a strong message to ERC and the EQB that these regulations are a problem and need to be disapproved and they need to start over. Thank you, Mr. Chairman.
Chair thanks the gentleman. I'm going to offer some comments and then proceed to a vote. I've held my tongue this far into the hearing. I will note that this committee has already discussed these regulations and this regulatory analysis form that was submitted to ERC for about 20 minutes longer than the Environmental Quality Board did. The Democrats, governor at the time of the Marcellus boom, offered no legislation to improve regulation. Democrat majority in the House, Representative Vitale, moved no legislation on the subject. It was when there was a Republican governor and a Republican majority in the House that we had finally the bipartisan support necessary to accomplish advancing regulations of the unconventional industry. And a statute was passed. The statute was rather controversial. As Representative Gobler pointed out, the Supreme Court struck down portions of that statute. But it's a difficult process. It has been ongoing. The Regulatory Review Act predates any of this, of course, goes back to 1970. And although some members here today have expressed that they don't much care for this proceeding, it's entirely contemplated by the Regulatory Review Act. And I'd go so far as say it's a duty of this committee to make a decision. And so here we are. Our system of government was established on the theory that government shouldn't break the law to make the law. In this case, we have many areas of concern. As Representative Vitale read into the record, the regulatory analysis form submitted to ERC was not actually the one which was considered by the Environmental Quality Board. There is no provision in the law to play three-card Monte and change what is approved by the submitting agency to what is actually delivered to the ERC. An out-and-out violation, which is easily established by objective evaluation. As Representative Causer pointed out, there was a premeditated decision to not comply with the Regulatory Review Act's requirement that all forms and reports that are required by regulation be considered side by side with the regulation. The forms that are embraced by these regulations are entirely central to what is going to be required of drillers. Rulemaking in the dark is explicitly prohibited under the Regulatory Review Act, yet that is what we had. And we had it on purpose. At the Environmental Quality Board, it was acknowledged that yes, the law requires this, and no, they're not going to worry about it. It's shameful. As Representative Rapp points out, the law requires, the Regulatory Review Act requires small business analysis to consider not just the fiscal impact on small business, but to consider are there alternative, less costly ways where the same objective could be accomplished. When the original RAF was submitted to ERC pointed out, this isn't there. And it's still not there. Something else that's still not there, although the RAF index says it is, are forms that were missing. Some forms are now there, others are not. But if you look at the index, it pretends those forms are on the public record, and they're not. As Representative Causer pointed out, the rulemaking in this fashion violates Act 126 of 2014. As Representative Vitale said on the floor at the time that that act was being considered, he opposed it because he understood it required that the rulemaking process with respect to conventional industry start over. He knew that. He understood that's what it said. The legislative intent was not confused.
Please don't speak for me. Please don't speak for me. Don't go into my thoughts and comments. I've been trying to get these regs passed
Representative Vitale,
for 4
you're
years.
out of order.
Well, you're referring to me. You're out of order, too. By referring to my motives, you are out of order.
No, that has nothing to do with your motives, Representative Vitale. It's to do with your record in the House Journal.
You're getting into my thoughts and
I
those
wouldn't
comments.
dare try to understand your thoughts.
Well, you've clearly just reread your
You're out of order,
transcripts. You just did. Well, you're out of order for doing that.
Representative Vitale, please suspend.
Oh. If you stop making misstatements about me, I will.
Well, we'll send you the page from the House Journal so you can refresh your memory.
Well, I'm sure it's not going to say he thought.
You're right. I'm sorry. He said. Let me correct the record. He said. Meaning he said. As Representative Metzger pointed out, the Technical Advisory Board is required under Act 13 to provide guidance on the regulations. The RAF falsely states the Technical Advisory Board has approved these regulations. It is actually not correct. What actually is correct is the most recent decision by the Technical Advisory Board on these regulations was disapproval. When the members that disapproved these regulations were all summarily dismissed by the current governor and replaced by his own appointees, that board never took an action on the regulations as a whole, but did instead make a rather thoughtful and extensive series of specific recommendations dealing with the technical application of regulations. All of those recommendations made by the governor's own appointees were disregarded in this rulemaking process. The governor also created this Conventional Oil and Gas Advisory Committee. Again, every one of the members was the governor's own appointees. That body voted unanimously in opposition to the regulations as presented. Now, those bodies are only advisory. One is statutory standing, the other is merely a creation of the governor. Others that are more grievous is perhaps, as we talked about before, the Supreme Court. The Supreme Court suspended application of aspects of Act 13. Those aspects were referred to in the original RAF as the source in law for the area of review sorts of requirements. The Supreme Court struck down those sections, and the department simply said then, well, it's not referring to those sections, it's other authority. Well, in the EQB meeting, the department acknowledged that they actually came up with this on their own motion, is I believe how they phrased it. The department doesn't get to make their own motion in lieu of statute. The department is supposed to be translating into regulations that which is already in statute. Which brings us to, what is the department's role here anywho? The Environmental Quality Board is unlike most aspects of state government. When we have regulations concerning the environment, they are not promulgated, not supposed to be promulgated by DEP. Instead, supposed to be promulgated and formulated by the Environmental Quality Board. The Environmental Quality Board has a statutory duty and is the only entity which in fact has this responsibility or authority to formulate the regulations. In this case, members of the Environmental Quality Board were foreclosed from participating in the formulation of these regulations. There is correspondence from members of the board seeking information in anticipation of input. There's questions that were raised at Environmental Quality Board meetings requesting information. Environmental Quality Board was foreclosed. Members were foreclosed from participating in the formulation. And the advance notice of final regulation didn't even pretend that have anything to do with the Environmental Quality Board. DEP, on its own motion, went ahead and published an advance notice of final rulemaking without even the courtesy of sending a photocopy to the Environmental Quality Board. The process has been hijacked. The addition of critical forms to the RAF after the RAF was considered by the Environmental Quality Board is entirely inappropriate. To my knowledge, these forms were not otherwise even today provided to the Environmental Quality Board. And just last week on this litigation dealing with these proposed regulations, the department, on its own initiative, hired counsel to reply to a complaint that had not been circulated to members of the Environmental Quality Board, and with a draft of a response that was presented as if it were from the Environmental Quality Board, that was never provided to the Environmental Quality Board until after it had purportedly appeared before the court. These are not mere technicalities. I will remind you that it was a Republican initiative that set forth to review and update regulation of the gas patch. Yet, I strongly believe that you cannot make law while you break law. And consequently, I will too be supporting Representative Causer's motion. Ms. Weaver, would you please call the roll on the question? Those supporting Representative Causer's motion will vote aye. Those opposed, nay.
Chairman Marr.
Aye.
Bloom.
Proxy, aye.
Causer.
Aye.
Christiana.
Aye.
Corbin.
Aye.
Everett.
Aye.
Gobler.
Aye.
James.
Aye.
McKenzie.
Aye.
Marshall.
Aye.
Metzger.
Aye.
Mustio.
Proxy, aye.
Pyle.
Aye.
Rapp. Sankey.
Aye.
Tallman. Chairman Vitale.
No.
Barban.
Yes.
Briggs.
No.
Gibbons. Harris.
No.
Kruger Beneke. McCarter.
No.
Newman. Schlossberg.
Proxy, no.
Schreiber.
Proxy, no.
Snyder.
The motion carries, and the chair will act in accordance with the motion to notify ERC and the EQB that the regulations are disapproved.
19 to 7.